Good evening, everyone. On behalf of the Government and Legal Studies Department, Bowdoin Public Service, Bowdoin Votes, and the McKean Center, I want to welcome you to this evening's conversation. My name is Sarah Chingos, and I'm the Associate Director for Public Service in the McKean Center. The title of this event, Anticipating the Unanticipated, has struck a chord with so many of us, as each day brings new layers of complexity and confusion that needs to be sorted, sifted, and processed in order to make sense of our upcoming election and how our next president may be determined. And so tonight, as good scholars and as good citizens, we look to experts for information and knowledge that can help us formulate a deeper understanding of where we have been and where we may be going. To help us do that, we welcome our three speakers. Andrew Rudalevige is the Thomas Brackett Reed Professor of Government and Chair of the Government and Legal Studies Department. He studies American political institutions with an emphasis on the modern presidency and interbranch relations. Michael Franz is a professor of government with research interests that span campaigns, voting behavior, campaign finance, and political advertising. An assistant professor of government, Maron Sorenson's research examines judicial politics, including strategic behavior, the separation of powers, and decision-making at the Supreme Court. Together, they will help us think about the various scenarios that might play out from the constitutional, electoral, and judicial perspectives. Before I turn it over to Andy, Mike, and Maron, just a few quick housekeeping tips. Each speaker will begin with a 5-minute statement, with Andy starting, followed by Maron, and then Mike. Following opening statements, they will pose questions to each other and build on the conversation. If you have a question, please put it in the Q&A function. You can also upvote a question that may have already been posed. I will be monitoring this and feeding questions to the speakers. I promise that we'll get to as many as time allows, with priority given to questions posed by students. I also want to add a quick note of thanks to Bethany Walsh and CXD for her technical assistance this evening. Thank you so much for joining us. And now I turn it over to Andy.
Great, thank you, Sarah. And it's nice to be here with my colleagues and with all of you out in the interweb, wherever you may be in time and space. I just want to give a quick background sense of Election Day in America generally. And to do that, we need to start with the fact that National Election Day, 1 week from today, is not national or one day. Obviously, the structure of American elections means that we're talking about 51 separate elections in the states and in the District of Columbia. And early voting began as early as September 4th in North Carolina. Most other states have since joined in, nearly all of them allowing voting beginning by October 16th. So that's 2.5 weeks before the formal election day. Votes will be counted well beyond election day. Right? Many states require ballots to be returned by mail so that they arrive no later than election day. Louisiana, you have to get it in the day before, in fact. But many also allow a grace period so that you can count the votes afterwards so long as they're postmarked by election day. That grace period ranges from 1 to 3 days for a bunch of states to as many as 2 weeks for Illinois, Michigan, and Utah. And more even in states like California, where you can get your vote in by November 20th, and Washington State, November 23rd. Just as crucially, of course, the president's elected not by the national popular vote at all, but by the Electoral College. The popular votes in each state are counted. The state government prepares, according to law, as soon as practicable, something called the Certificate of Ascertainment. And that certifies the electors who are chosen by that state. Controversies in the state, and I'm sure we'll get to some of those, are supposed to be resolved by December 8th. That's called the safe harbor deadline for state action. So maybe then we actually come to election day, right? The first Monday after the second Wednesday in December. That's December 14th, by the way, this year. The electors meet in their states, right? They don't meet together. Constitution specifies that they meet separately, the better to avoid demagoguery. And the college, in that sense, is not particularly collegial. Right? They never meet each other. But after their meeting, and we can talk as well later about the idea of a faithless elector, who electors must choose, but normally they follow the winner of the popular vote of their state. They produce certificates of the vote, these parchment documents that are then sent to the president of the US Senate and a few other places. To arrive no later than December 23rd. Okay, so maybe election day is actually January 6th, 2021. That's when a joint session of Congress meets and reads the list of the votes, right? They tally them. Objections can be raised to any state's votes, and there are procedures for then going through the controversy and the objections. Again, we can come back to that. If one ticket has a majority, 270 votes or more, of course, they are deemed elected. If there is no majority, then the House gets to choose from among the top 3 vote getters in the Electoral College. The Senate chooses the vice president from the top 2 nominees there. Inauguration Day is, of course, January 20th. Now, most of what I've just said is normally invisible. Right? We don't pay much attention to it. We watch TV on election night and we see states light up as red or blue. Someone declares victory, someone concedes, but not always, right? And of course, that's one of the reasons for our meeting tonight. But I do want to give you 2 quick examples from US history before handing over things to Professor Sorenson. 1876, perhaps the most contested election in US history in some ways. Democratic candidate Samuel Tilden won the popular vote, probably. There was a lot of weird things going on in 19th century elections, but he won the popular vote probably by about 250,000 votes in one of the highest turnouts in US election history, 82% actually. He led in the Electoral College too by 18 votes, 184 to 166, but you need 185 as of 1876 to win the Electoral College. And there were handily 19 votes that were contested. The states of Louisiana, Florida, South Carolina, and 1 elector from the great state of Oregon. Ultimately, a special electoral commission had to be passed in law. This was at the request of then President Grant. It was made up of 15 people, 5 members of the House, 5 of the Senate, and 5 from the Supreme Court. And they met and then wound up voting under severe partisan pressure along exact partisan lines, 8-7, and managed to award every single disputed vote to Rutherford B. Hayes, the Republican nominee, who therefore won the presidency 185 to 184 and threatened a second civil war, only 15 years, not even 15 years after the first had ended. This was ultimately fended off when a group of Ohio Republicans, Ohio is where Hayes was from, met with Democratic leaders and basically cut a deal. The most important part, the one that we remember perhaps the least fondly, is that Union troops were withdrawn from the South, therefore allowing the restoration of segregation and racial brutality in the South for at least another 90 years. It also led to the Electoral Count Act of 1887, by the way. But we can come back to that. I should note that the Electoral Count Act vests some power in the president of the Senate, who happens to be the outgoing vice president, but also in Congress. And Congress, of course, as of January 6th, will be the new Congress that was elected in November and which will have taken office on January 3rd. I'll mention quickly as well an election that at least some in the audience may remember, again, fondly or not fondly. That was, of course, the election of 2000. When Al Gore, the vice president, ran against George W. Bush, the governor of Texas. Very close election. Florida was the key state, the tipping point for the Electoral College. Whoever got Florida would have 270 electoral votes. In Bush's case, almost exactly. It would bring him to 271. Originally, the networks began to think that Al Gore had won Florida. Bush was dubious. He had some good vote counters on the ground, and besides, his brother was governor of Florida at the time, and wound up not conceding. A little later, it looked like Gore was losing, that Bush's guess had been right, and Gore got as far as making a concession call only as votes kept coming in and the margin kept getting closer, only to retract his call, to which George W. Bush objected, and Al Gore apparently said, "George, don't get snippy." In any case, the election dragged on, right? The electoral count was something in the 300s, right? In a state with literally millions of votes cast. Different counties began to recount their votes. They had different kinds of ballots. There were all kinds of famous things that came out of this election, including famous pictures of people looking at ballots to see what the chads were that people had tried to punch out of a paper ballot. famous the Brooks Brothers riot of young Republican lawyers pounding on the doors of electoral commissions, and ultimately a series of court cases, most famously, of course, Bush v. Gore, which went to the Supreme Court and by a 5-4 margin prevented the Supreme Court of Florida's efforts to continue the counting of the ballots. That was on December 10th. On December 13th, Al Gore conceded 36 days after the election. And Bush v. Gore is actually a pretty good place to hand things over to my colleague, Professor Sorenson. So I'll do just that.
Thank you, Professor Rudalevige, and thank you for the committee for organizing this. It's great 1 week out to try to make some preemptive sense of everything. So I'm going to take over and discuss Bush v. Gore in a little bit more detail, and I'm going to try to slot some important events into the timeline that Professor Rudalevige provided about the safe harbor deadline, et cetera, and then see if there's any resounding lesson that we might take from Bush v. Gore that we can apply to what might happen in the days after, well, just a week from now. In 2000, election day was 11/7, November 7th. And by November 8th, Bush had a 1,780 vote lead. That was under 0.5% of the total vote count. And so by Florida law, that triggered an automatic machine recount. So Al Gore didn't even have to ask for that. Just by Florida law, that happened automatically. And a machine recount, whenever I talk about this in class, students sometimes laugh thinking, what is that? And Professor Rudalevige kind of mentioned this. Ballots used to be almost like Scantron sheets. So you would, in some states, fill them out with pencil. In states like Florida, not in every single county, but in many of the counties in Florida, it was a punch card. And you would put it into a voting machine that almost looked like a cheese grater. And the cheese grater had holes in it so that when you punched with a little stylus, you were punching through your ballot card. And then the chad was the punch that you were supposed to remove so that your intent as a voter was very clear. If in fact you did not remove the little chad, that was the origin of a hanging chad. If you didn't press it hard enough to even sort of just make it hanging, it was called a dimpled or a pregnant chad. And there was also, some chads were hanging by 1 corner, some chads were hanging by 2 corners, some chads were hanging by 3 corners. Some of them didn't even detach at all, and those were the dimpled or pregnant chads. So the machine recount, however, would just have taken those physical ballot cards and put them back through the Scantron machine. After the machine recount finished, the Bush's lead was narrowed down to 250 votes. Gore, also by Florida law, was able to ask for manual recounts because the margin was so low. In Florida at the time, if the margin was between 0.25% and 0.5%, you were able to ask for hand recounts. So the Gore team requested hand recounts in 4 traditionally Democratic counties. And in those counties, this is where the election officials were, as Professor Rudalevige was saying, the famous pictures, you can look them up with magnifying glasses. They were trying to determine voter intent by examining the ballots that the chads weren't entirely removed. So by 11/10, or 3 days after the election, was when the machine recount was finished. By Florida state law, the Secretary of State of Florida was supposed to certify election results 1 week after the election day. So on Tuesday, November 14th, the Florida Secretary of State was supposed to have validated those. However, 2 lawsuits were brought on Monday, 11/13. One was a federal case that was initiated by the Bush team. Another was a state court case that was initiated by one of the 4 counties because they wanted to continue their recount. On the Monday, the 13th, they weren't done with their recount, and they didn't expect to be done by Tuesday, when Florida state law says that the Secretary of State is supposed to certify the election results. So these stays went in. A Florida judge said the Secretary of State could keep the 11/14 deadline, but must actually give due consideration for requests for extensions. And Bush's appeal failed because he wanted to stop the manual recount, because the manual recount generally would have favored Gore since it was in these 4 Democratic counties. So on the Wednesday, 11/15, the Florida Secretary of State rejected all 4 counties' requests for extensions, saying that she had given this due consideration and said that no further votes would be considered. The 17th, the Florida Supreme Court barred the Secretary of State from certifying the results until further judgment was issued. At the same time, now this is the 3rd case. There is now this 3rd case. The Bush appeal to stop the recount had gone to the 11th Circuit Court of Appeals. They had allowed for the manual recount to continue, and the county that had asked to be able to continue, the Florida judge ruled that the Secretary of State did not abuse her power in granting no extensions. And so that case, the Florida judge ruled that it was fine to have stopped the counting on the 14th. Nothing wrong there. So I'm not going to go into every single detail, but I want to give the idea that things were very messy and that you had interest on both sides, where the Bush team was generally trying to stop the manual recounts, the counties from continuing the manual recounts, and the Gore team was trying to ensure that the manual recounts were continued. One of the things that I would advise, if you're going to be a court watcher in all of this, to watch out for is when the Supreme Court is involved and it issues a stay, an emergency stay. So the Supreme Court can stop before it's going to actually hear the merits of a case. It can stop a lower court from either allowing a judgment to continue or stopping a judgment from happening. So on 12/9, so in Professor Rudalevige's timeline in 2000, the safe harbor deadline was 12/12. And the day that electors were meant to cast their ballots on the first Monday after the second Wednesday of December was 12/18. So the Florida Supreme Court, after all of this, had demanded a statewide manual recount of all of the sort of hanging Chad ballots. 12/9, the Supreme Court stayed that judgment. So the Supreme Court interrupted what Florida had done and said, hold on, I know Florida Supreme Court, you just said that there should be a statewide manual recount, but hold that thought because we might get involved. So there are 3 things that the Supreme Court is meant to consider when it's going to issue a stay. So the first is this idea that they might actually hear the case on its merits, otherwise known as they might grant certiorari. The second is that there is a fair prospect that they will overturn the lower court's decision. And the third is that allowing the lower court decision to stand and to be implemented would produce irreparable harm to the plaintiffs. So if the court gets involved by issuing a stay, it's certainly not 100% a decision before the decision, but it certainly forecasts what could happen because of the 3 factors that the court is meant to consider. So on 12/9, the Supreme Court stopped the Florida Supreme Court's issue or guidance that said that it was supposed to be a statewide recount. 12/12, the Supreme Court of the United States issued its judgment in Bush v. Gore, and its judgment had the effect of awarding the election to Bush. The opinion did not award the election to Bush by saying we award the election to Bush, but it had that effect because the Supreme Court overturned the Florida Supreme Court's decision to allow for the recount to take place. And since at the time, Bush was still in the lead and no more counting was allowed, then Bush won Florida. The court reached that decision on the equal protection grounds. the Equal Protection Clause of the 14th Amendment by saying, because Florida has chosen to give the franchise of voting to people, you therefore cannot value some people's votes more than other people's votes. And the Supreme Court said that was happening because individual precincts, let alone counties, were using different standards to physically examine the ballots to determine voter intent. So one precinct might be saying that if the Chad was hanging by one corner, that counted as clear voter intent, while another precinct might say that if the Chad was hanging by two corners, that counted as voter intent. So because the court issued its judgment on the safe harbor deadline, which was the time that states were supposed to have their electors selected, that there wasn't time for Florida to stipulate a single standard for determining voter intent and then produce the recount accurately and then go through the process of certifying the election results and selecting the electors, etc. So what lesson might we take from that? We can take from this a few things. One is that the lesson that I told you about the stay. If you see the Supreme Court get involved by issuing an emergency stay, that's a pretty good forecast that they're going to get involved. Even though they've said that they don't want to be involved, they're going to probably get involved. And the second is this idea that states should have clear guidelines in effect for determining voter intent. So with absentee ballots or mail-in ballots, it is possible that there will be challenges and there will be requests for manual recounts where individual precincts are asked to determine, right, did that tick mark that person, is that clear? Is that clear voter intent or isn't it? And so states would do well to have a clear standard articulated for any precinct that would engage in manual recount to determine voter intent. Yeah, so lots of messiness involved. And I think that's probably the best line that I can hand it over to Professor Franz with, because he's gonna definitely have a lot of messiness to discuss. Sorry about that introduction, but it's you have a tall task, sir.
Yeah, well, we'll see. I was going to say that I'm grateful for that recount of the events, but I'm not sure if that's a good joke or not. I also realize that I'm at a bit of a disadvantage because there are no books behind me, and I have books, I promise, but they're just not here. So I want to talk a little bit about where we are in a couple of big sort of points to make about the sort of status of the current election, and that'll get us into a little bit of understanding of where we're going. The first is that this is an election with historic spending. So the Center for Responsive Politics has estimated that federal elections this year will amount to about $11 billion in spending across candidates, party committees, and outside groups. My research is on political advertising, to include TV advertising, radio advertising, and now digital advertising. And we were just looking at some of our data for TV ads, which are traditional TV ads broadcast live over the air on television, on local news broadcasts or game shows. Not many of us watch live TV anymore, but a lot of people still do. And in this election cycle, there's been $3.1 billion in spending on TV ads on broadcast TV stations. And that amounts to 5.4 million ad airings between January 1st, 2019 and October 25th. And I did a little bit of calculation. And if you were to watch each one of those 5.4 million ad airings back to back, it would take you 5 years, 24/7. So there's a lot of TV ads and across the country, and they're clumped in different places depending on competitive Senate races, House races, and competitive presidential races. And sometimes you see all three of those in a state. And so it's astronomical spending, no matter how you scale it, whether you adjust it for inflation, compare it to the size of the economy over time. This will amount in total to one of the most expensive elections in American history, surely in absolute dollars, but even rescaled to understand it in relation to the size of the economy. That explains, or maybe reflects, the intense interest in this election. One of the most anticipated elections in American history, certainly in modern American history. And we can track that a little bit by looking at the early vote. Now, early vote is, of course, reflective this year of the COVID-19 situation. So a lot of people are turning to vote early. But there has been a trend over the last number of decades of more and more Americans choosing to vote absentee or early. And in 2016, about a third of the vote was absentee or early vote. I just looked tonight at the numbers, and we are just shy of 70 million total votes already cast in this election. There was 130 million votes roughly cast in 2016. So we're already over 50% of the total vote in 2016. Now, that's partly a COVID effect, as I said, but also a reflection of the historic interest in this election. I think if we weren't in a COVID situation, we would undoubtedly see record turnout both early and on election day. And maybe perhaps we'll still see record turnout in terms of modern American elections. Roughly in the last number of decades, a good election will be about 60% of eligible voters. I think we could see close to 70% of eligible voters this time. If we don't hit 70, we'll get in the high 60s. And you have to go back to roughly 1900 to see an election with turnout at the eligible vote that high. So even in a situation where we're dealing with a global pandemic, the interest and engagement of Americans in this campaign is above and beyond a lot of what we've seen. And we see that in the spending also. And so that puts us at a final point I want to make, which is about what we're all watching day to day, which is the polls. And we do this consistently. We watch them almost obsessively in various states, if we're interested in certain Senate races, and certainly the battleground states across the country. And then some folks use that to build forecasting models that give us probabilistic assessments of who's likely to win. And Nate Silver being probably the most famous. And so one question that people often ask is, can we believe the polls? Can we trust them? In 2016, they gave us forecasting models that in some cases had Hillary Clinton winning at 99% chance, or in Nate Silver's case, a 67% chance. And all of that kind of shocked people on election day when Donald Trump won. But the post-election analysis of the polls in 2016 showed that national level polling was actually pretty good. It showed Hillary Clinton was going to win the popular vote, because that's what a national poll is really tapping, and she did. But the state level polls in many battleground states were not so great and mispredicted the outcome in states like Wisconsin and Pennsylvania. And that was the sort of post hoc analysis of that, or the post-election analysis of that, identified the likely source of that, which was some response bias on the part of non-college educated white voters, or the working class white voters that have heavily moved to Trump's camp in 2016 and have stuck with him over the years. And a lot of polls didn't account for underrepresented working class white voters in their samples. In the past, education wasn't a very strong predictor among white voters of how you would vote. It was not much of a distinction amongst white voters between those who had a college education and those who didn't. But that had been trending slightly differently in recent cycles, and it finally became a huge distinction in 2016. Pollsters, I think, have likely accounted for that now. They've figured out that they need to control for education, adjust for it, wait for it, and make sure that they have a representative sample in that way. And so I think my sort of gut instinct on this is that, and knowing what pollsters have done over the last few years, is that the polls are likely good reflections of where the voters are. It could be wrong for any number of other reasons, but are probably much better off than they were in 2016. And if you look at the state of the polls in Wisconsin, Pennsylvania, Michigan, you do see Biden with leads. They'd have to be wrong again by a decent amount, even after fixing the influence of education amongst white voters in those states. And that would have to be for other reasons beyond that, likely. So where we're going, I think can be considered by what the polls are saying. And although they shocked us in 2016, we should be in a firmer ground this time around. And I think that that might give us a sense of what is likely to happen on election day or in the weeks and days after election day as the votes are counted and processed. So that's where I'll stop, which is sort of a sort of sense of where we are right now on spending, interest, and likely voter support for each candidate.
Great. Thanks, Mike. I'm going to ask a follow-up question that has come in. And as the questions come in, I'm going to jump around a little bit, but I'll try to get to as many as I can. There was one follow-up question for you, Mike, regarding what kind of statistical relationship is there between money coming into a race, or maybe the number of donors and the outcome?
Huh. That was a midterm question I just asked. So thank goodness that was last week. There is a statistical relationship between spending money and outcomes. You got to spend money to win. But what's interesting about that, and I won't talk too much about the presidential race, but what we do know, because we have a lot of data and evidence in congressional races and in other races down ballot, is that there seems to be a strong relationship between electoral success and spending, especially when that candidate is a challenger. And there seems to be less of a statistical relationship between electoral success or vote change and spending by an incumbent. Now, that's not to say that an incumbent doesn't get some benefit from the money they spend in a campaign, but they're already much more well-known, and the effect sizes are a little bit smaller and complicated by the fact that most incumbents who spend the most are the ones in most of the competitive races, and the incumbents who spend the least are the ones in lopsided races who are likely to win. So statistically, it's hard to sort out the effect for incumbents. But for challengers, we know the more they spend, especially relative to the incumbent, the better they do. And that's one of the reasons why there's so much money that needs to be put into campaigns in order to stay competitive with incumbents who have a built-in fundraising advantage. One thing I'll just say real quickly is that what we're seeing in 2020 is astronomical spending from Democrats who are running in lots of places as challengers against Republican Senate candidates. We're seeing that here in Maine. They're outraising and outspending by substantial amounts Republican incumbents. And those Republican incumbents will still do okay relative to their Democrat because they're well known in the state and have some built-in advantages as the incumbent. But it's taking that outside spending by Democrats to keep them in many of these races and to make those races competitive.
Yeah, if I could add very quickly, just to note that a lot of money is coming in from outside a given state also, especially in the age of the internet, where you can easily just get on your app and decide you want to give a little donation to somebody in Texas or Oregon or Florida. And so that won't necessarily correlate automatically with support within a state. But certainly having money within the state will help you. And, those of you living in Maine might have decided that the Senate campaigns at least have too much money. They don't know quite how to spend it. They're sending you 20 mailers a day. Every radio commercial is a Senate ad. I haven't heard radio ads for 30 years. This is amazing. So it's there is a correlation, as Mike says, but I'm not sure you can necessarily say it directly links to in-state support.
Does any other country spend on political campaigns at the rate that the US does, or are we alone in that distinction?
No is the answer, right, Mike?
I would say no, right? And you both know a little bit more maybe about, maybe our direct friend, the British politics perhaps, but there's a lot of there's a lot more restrictions on spending in campaigns and other democratic systems, shorter campaigns, more restrictions on who can spend. We have this tricky thing called the First Amendment, which is written into the Constitution, which the court has, as Professor Sorenson knows, has favored spending as equivalent to or an example of speech. And so since speech is protected, so is spending. And that allows a lot of outside interests and candidates to raise lots of money and advertise.
Great. How might the elevation of Amy Coney Barrett to Supreme Court affect how the court may become involved in this election?
So it would be very wise of her to recuse herself. And it would be very wise to do so to protect the court's overall institutional legitimacy. So individual members of the court after Bush v. Gore were not shy about saying they did not want to be put in that position again. And especially when the outcome was 5-4, 5 conservatives versus 4 liberals. Even if you want to believe that the Equal Protection Clause was the correct doctrine on which to found that opinion, the optics of it don't look good, and that harmed the court's legitimacy. If you now would have a justice who was placed on the court by a president who has made public statements that he's hoping that the court will side with him, that would be really detrimental to the court's institutional legitimacy. Why does institutional legitimacy matter? In court scholarship, in examining sort of public opinion, the nexus of public opinion, institutional legitimacy, and compliance, the court, obviously, because of the separation of powers, does not enforce its own decisions. And so it relies upon what we call in the scholarship a reservoir of goodwill. It relies upon its own institutional legitimacy for people that otherwise maybe wouldn't agree with the court's opinion to go along with it, to comply with it, or to, in fact, be an enforcer of it if you're in a position of government that you would need to do so. So whenever the institutional legitimacy of the court is eroded, that has an impact on the way its individual decisions are taken, especially if those individual decisions run a partisan vote count in the future. So Amy Coney Barrett absolutely could impact. I mean, she would be the 6th, but Roberts has been a swing vote recently. So it is possible that in a different situation, Roberts would have acted potentially with 4 liberals if Ruth Bader Ginsburg was still alive. And if you had a situation where he sided with the now 3 liberals and there was a 5-4 split again, that couldn't look worse for the court's legitimacy. So she can, and there are vague precedents that the court has determined where in lower courts, there are circumstances where a judge should recuse themselves. But that standard has never, ever been applied to the Supreme Court. And maybe you'll famously remember Justice Scalia when asked after he had gone duck hunting why it was okay for him to not recuse himself in cases where Cheney or the Bush administration had an interest. His response was quack, quack. So no one can make the justices recuse themselves, at least not yet. She could absolutely impact and vote in outcomes because she's been sworn in. So if she receives full consideration of a case by receiving the briefs, participating in oral arguments, she can vote. And it would, however, be very detrimental to the court as an institution for her to do so.
I can just note, I mean, if Mike is right about the polls, if we have faith in the polls, then, you know, this our session here about the unanticipated may actually just be a celebration of the anticipated, given that those polls have been showing the same thing for an entire year, you know, even before impeachment and COVID and, you know, the whole range of crazy things that have happened in 2020 itself. And so, you know, there's some possibility you'll sit down and Florida will go Biden's way and North Carolina will go Biden's way and Arizona will go Biden's way. And there's not much of a controversy. On the other hand, if states are close, right, the nightmare scenario that Pennsylvania, for example, is on the knife's edge. And that's the state that would tip either candidate over the edge. And having lived in Pennsylvania for 12 years, no offense to those great residents of the Commonwealth who may be in the audience, they're not ready for this any better than Florida was in 2000. Actually, Florida now is quite ready.
Yeah.
I suspect Pennsylvania is not, and Pennsylvania also has a huge partisan divide between its governor and its state legislature. You can see there, right, these disputes start in the state courts. In fact, Maron can correct me, but my memory is that in 2000, there was actually some question as to whether the Supreme Court had any role at all in this dispute, because it was not a federal dispute. The votes were supposed to be handled at the state level. And it was only by bringing in a constitutional standard, equal protection of the law, right, that the Supreme Court was able to deal itself in, if you will, into this dispute. And obviously, the fact of the legislation trying to protect the timing of the Electoral College vote played a role in that as well. So it's possible the Supreme Court could, in this case, decide, well, we don't want to get involved. It's possible, that Bush v. Gore, by the way, said directly in it, you should never cite this case again. It never happened, really. It's not a precedent for anything. Don't look at it, please.
Kavanaugh just cited it, if anybody's curious.
Yeah. And Brett Kavanaugh, by the way, was one of the people pounding on election commission doors back in 2000. And this is just, that's not to pick on him in particular. It's just to say that members of the court have backgrounds. They have political backgrounds. They have political preferences. We shouldn't pretend the court is not political. And that's not a new thing either. Remember, 5 Supreme Court justices were on the Electoral Commission in 1876, and they voted along party lines. So I tend to agree with Professor Sorenson. The court should stay out of it if it can, and if it can't, then I don't actually know what the right thing will be, because we're talking in very hypothetical terms. But I hope it will do something that maintains its legitimacy and is clearly right to the degree possible, such that its decision is accepted by the American people. That was made much easier in 2000 because Al Gore accepted the result of the court. He did not push his case further. He did not try to contest the results in Congress. In fact, he was, remember, the vice president. So he had to read the results, which he must have disagreed with, certifying George W. Bush as the next president of the United States. And he did that with some dignity, as, by the way, did Richard Nixon in 1961. Nixon in 1960 lost an extremely close election where there's a halfway decent case for voter fraud in at least a couple of states that ultimately went Democratic. Nixon, too, for the good of the country, decided not to contest the election. I'm not quite certain that anyone in the current race will step back for the good of the country, possibly because they think the good of the country lies in their elevation to the presidency, and that disaster lies in the other direction in a way that we didn't see in 2000 or 1960.
I want to jump back to you. We're talking about Pennsylvania, and there's a question that came in that says, punditry and electoral forecasts have emphasized the importance of Pennsylvania in this election. Are the naked ballots being used in Pennsylvania another quote unquote hanging chad waiting to happen? Or is there enough of a uniform standard to determine voter intent and avoid a consequential court decision?
So my understanding of what has been decided, and Mike, you might know, or Andy, is that they have said quite clearly that naked ballots are not accepted. Some states have allowed exceptions for signatures that don't match, where they would allow an individual 2 days to rectify a signature that doesn't match or a signature that isn't placed. But so far, the signal from Pennsylvania is we don't accept naked ballots, full stop.
So a naked ballot, just
for standard. Yeah.
Folks out there, is if in Pennsylvania, the law is if you're returning an absentee ballot, you need to put it first in a secrecy envelope and make it not naked. And then you put it in the actual envelope with which you mail it to, the appropriate election authority. And so it's that middle step, right, to make sure that you clothe your ballot so that people can't see it when they first open your envelope. I had a student refer to it as naked voting, which I thought was a lot more fun sounding, but no, it's just naked ballots. But yeah, I think Professor Sorenson's right. It's that I believe is settled, right? The state has decided that is going to be its clear standard. And so I think that's probably not something you could litigate at this point. Pennsylvania, of course, is also arguing about whether it can have a change in law that allows it to accept ballots a few days later than Election Day because of the issues with the Postal Service. Supreme Court just ruled 4-4 not to take that case immediately and to let Pennsylvania accept ballots late. I mean, that's another question associated with the confirmation of Justice Barrett, is whether she would then provide a fifth vote to overturn that decision. But again, it's a pretty clear state decision to do that. So I think
however, that was made by the state Supreme Court.
Mm-hmm.
It wasn't a state legislature decision. And it's the although every other piece of sort of voter, what you might consider a voter accommodation, so maybe some sort of extended deadline or having boxes that are more accessible, all of those previously where the Supreme Court has invalidated a lower court judgment have all been federal district court judgments. So while Pennsylvania is the one unique outlier where they tied 4-4, and when there's a tie, the lower court decision is upheld, it's not overturned. And it was the Pennsylvania Supreme Court there that decided that Pennsylvania gets the 3 extra days to receive ballots that would be postmarked prior to November 3rd. So the court, however, is by its own standards running out of time to intervene there, because it was very clear in RNC versus DNC, the Wisconsin case, that you can't be changing things too close to the actual election itself, because voters might have made their decisions about the way that they would vote under one set of assumptions. And if that set of assumptions changes too close to the deadline for voting, then you would have voters' intent that was clearly expressed under a set of rules correctly, that then because the court changes those rules would be invalidated. So even if the court hears the Pennsylvania case, the exact same case again with Amy Coney Barrett, it wouldn't be great for them to go against their own precedent in now changing that lower court ruling, invalidating it, and putting the date at which ballots must be received back to November 3rd.
Precedent is for chumps, Maron. I'm sorry. It's no. We'll see. No, I think you're absolutely right. And by the way, you raised a very important point, which is this notion of the legislature. Because if you think about the way that electors are appointed in the first place, right? That is by state law, and indeed the Constitution in Article 2, anti-pocket Constitution, right, talks about.
Mike, where's yours?
He's got no books. He's got no Constitution.
It's on my phone.
It says, that each state shall appoint in such manner as the legislature thereof may direct a number of electors, and so on, right? So if you want to go whole hog, right, that just means the legislature, not even the governor, certainly not the Supreme Court of Pennsylvania, right? And so, thinking about potential legal challenges afterwards, right? Barton Gellman wrote a very, nightmarish scenario up in the Atlantic magazine this month, I guess, that was online earlier, talking about, right, a Republican legislature just appointing willy-nilly Trump electors in place of those selected by the election. Though, again, that would depend on a state being close, I think, and on, there being some plausible reason to think that the will of the electorate had not been met.
Well, and Andy, that would be framed in a way where they would actually frame that decision to be, in their eyes, reflective of the popular will. They would never overturn the popular vote. What they would say is that the evidence is so conflicting, we're going to believe this set of facts, and this is allowing us to affirm the popular vote. And that's how they would frame it. And I think the nightmare scenario would be where, and I say nightmare not for the outcome purposes in terms of Trump winning, but for the uncertainty around the election, would be if Trump were to run the table on the current battleground states like Florida, North Carolina, Georgia, Iowa, and Ohio, and then and we see contested outcomes in Pennsylvania and Wisconsin coming down to these kinds of questions. If Biden can win Florida or North Carolina, if he can win, even Georgia, if he wins one of those states, I don't see how Trump can actually win the election, even if there is a contested vote in Wisconsin or Pennsylvania. Of course, he could still win it mathematically, but I think it would likely indicate that he has stronger support than the polls would suggest in those battleground states, and he might even win Iowa or something. And all of that would stack up in favor of Biden winning, and it would be very hard for the president to try to undermine that outcome if there's at least 2 states that have some cushion for Biden. And so, but it's not impossible to imagine a scenario where Biden loses those battleground states, and it does come down to this kind of back and forth in Pennsylvania and Wisconsin.
Is this a good time to talk about faithless electors?
Oh, wait, can I mention just one quick thing, Maron, first?
Yeah.
Which is just to say that, remember that states have different rules as to when they can start processing early votes
Yep.
and ballots, right? And in some cases, that's before election day. And then it's actually pretty easy to just work them into the totals that are announced on election day. But there are other states, including Wisconsin and Pennsylvania, where you're not allowed to even start looking at room really until election day itself. And so that could add to the time it takes. So in Mike's, uncertainty scenario, that would add to that uncertainty because you'd have quite a while while, these poor local election clerks go through. Remember, these are your neighbors. These are just normal people. There's not some magic group of electoral officials that descend from on high to conduct these elections.
They're statistically
States is
older.
Well, they are kind of heavenly. They're angelic, actually.
Yeah.
I shouldn't deny that. But again, they're normal people, and elections. We spend a lot of money on elections. The other thing that's weird about the United States is that they're conducted by partisan officials, right? We elect secretaries of state. Sometimes we elect town clerks, depending on where you are. And
Wisconsin has a bipartisan commission, don't you?
I think they do. Yeah.
Yeah.
Yeah, but that's been contested as well. Republicans have taken over the state legislature, and they had one of the most well-respected election ethics boards in the country, and that has been undermined by the Republican legislature a bit.
They've really done a number in Wisconsin in the state.
Well, yeah, I mean,
legislature.
Wisconsin reflects in many ways the polarization that's happening nationally. I mean, when you see the sort of intransience and the difficulties that emerge between the Democratic governor and the Republican legislature around everything involving even something like a mask mandate, you can see kind of easily how it could shake out in a bad way in terms of counting the vote in the state if it was close and it came down to Wisconsin. So they don't have an easy way of resolving that partisan bickering. Of course, reflects something we see at the national level as well, and that's showing up in Pennsylvania too. Even when you would argue, I think, I don't know as much about Tom Wolf, but I think that the Democratic governors in these states are fairly mild-mannered, but they still can't seem to find ways to work with the Republican legislatures. So that would all lead you to believe that it could get dirty there if it was close.
So are we teeing up Chiafalo for you, Maron? Is that the Faithless Electors and the magic of
sure, because you had previewed it in your intro, and so I was just going to give a little background. So faithless electors, because electors are actually people. They're not just votes. They are people who cast votes, and the Constitution doesn't provide a lot of guidance about the way that it doesn't provide any guidance about the way that an elector makes his or her decision. And so if you're an elector and your state goes for Biden, could you actually cast your electoral vote for Trump? So 33 states have faithless elector laws that attempt to address that scenario. And the Supreme Court has said that states can outlaw faithless electors. So a lot of the states have laws that contain no penalty whatsoever, but contain a mechanism that would invalidate that elector and then replace them with a faithful elector. So that's out there. So there is still the opportunity for it. There are some states that make a fine, a civil penalty of a fine, but then don't replace or invalidate the vote. So there is opportunity for faithless electors to shake things up a little bit. It's happened in the past, not in the way that would have decided an election, but in a way that they cast their vote against what their state has chosen.
What we seem to be outlining here is a very clear argument for a choose your own adventure election craziness outcome here. You could write a whole book that would be like faithless electors go to page 25, contested absentee ballots go to page 32, right? And so it's yeah.
Well, so this might tee up a final question, which is that someone asked, a student asked right at the very beginning, which is, given that Chile is about to redo their constitution, which is only about 40 years old, is it fair to say that it's time for us to reconsider maybe creating a new constitution after 231 years to prevent rampant voter suppression that we've been witnessing this election?
Well,
How to answer?
I would say just real quickly that I think I don't know enough about the consequences of what this would entail, but I think it's time we consider potentially a constitutional amendment that would provide a guarantee for the right to vote. I think I don't know how that would be structured in a way that would be comprehensive, but we actually don't have an affirmative right to vote in the Constitution. And we have other protections around due process and equal protection of the laws. And we have preventions of people being denied the right to vote, but an affirmative statement that would provide cover for Congress to do any number of things that would give people the right to vote would be, I think, something to consider. A whole-scale revamping of the Constitution I wouldn't approve, but I do think the partisanship of the moment suggests that we could come together as a country and make a positive statement about the fundamental component of our system, which is the voting process.
Yeah, I guess I would add to that, I mean, voter suppression, right, carries a lot with it and could refer to a whole bunch of different things, including the purging of voting rolls on the one hand, but also just not having enough resources to handle an election in which people are interested, right? And if you've seen, some of the early voting lines, that's a problem, right? If you've got to spend 12 hours to vote instead of 20 minutes, that is a cost put upon you that makes it harder for you to actually exercise your rights. So it could be that the kind of amendment Mike's talking about might lead to increased appropriations, for example, federal support for state administration of voting. Remember, the Voting Rights Act, has been reinterpreted by the Supreme Court in recent years to allow for less federal enforcement of the way in which states manage their elections. So you could perhaps reverse that. But again, that might take an amendment. I mean, the question that's almost always asked when it comes to the amendment question is, should we get rid of the Electoral College? And that would take way more time than we have now to discuss in detail. I would say, the automatic answer is always say, yes, we should definitely get rid of it. It's undemocratic. I would say that there could be unintended consequences to a shift to a national popular vote, at least without thinking about ways in which you would try to guarantee that a majority is actually represented in the election of the president. If you had a national popular vote, for example, without any other shifts, you could think of 4 or 5 or 8 people running for president nationally, and the winner by plurality vote, 25 or 30% of the vote. Would that be more legitimate than somebody winning the Electoral College? So you'd have to think about it in terms of adding a runoff election or ranked choice voting or some kind of other mechanism to try to aggregate a majority, I think. And it's worth remembering, right? The country is a big place. The rationale for requiring candidates to try to pull together a geographic coalition that could propel them to the presidency, I guess I would just say we want to think about whether that is now passé, whether that no longer applies, right? Obviously, the Electoral College is not democratic in a small d sense. It is Republican in a small r sense, and there may be some advantages to that. I also think it would be very hard to change, by the way, in a practical sense. But again, I could argue both sides of this question for much more time than we have. But I do think, of course, the larger the difference between an electoral vote winner and a popular vote winner gets, to the degree that, the margin was, 500,000 votes in 2000, closer to 3 million votes in 2016. If it were 6 million votes in 2020, and, the popular vote loser still won the Electoral College, I think you would see more pressure for change at that point.
I'll be very quick.
Okay,
I'll
go ahead.
just say that I like Professor Franz's idea of a voting rights amendment. And I would want to see some of the congressional legislation from the enforcement clause that we had a national holiday that would be an election day. And I would even like to see us adopt something similar to Australia where you'd be required to vote. And there is a norm in Australia that you would go and vote, but if you didn't actually feel strongly or you're not informed on the candidates, in order not to be fined because you didn't vote, you do what's called cast a donkey ballot, which is you intentionally mess up your ballot so it can't be counted, but you have done your civic duty, you didn't get fined, So I think there are ways that we can avoid having to throw out the entire Constitution. We don't need to necessarily set it on fire, but there would be things that could definitely increase or decrease this sort of voter suppression that's happening and increase potentially civic participation. That's my quick 2 minutes.
I've got one other, I said that was going to be at the end of it, and I'm going to wrap up. I have one other really quick question because I think it's on the minds of a lot of people. And that is one question that came in where if Biden were to win the election, can the office of the president from an executive standpoint interfere with accepting the election results?
No.
Probably, yeah.
No.
He,
Okay.
He'll try.
No, I mean, it would be vested. No.
Okay.
Not legally.
Right. All
Yeah,
right.
the 20th Amendment ends the president's term on January 20th at noon. And that's that.
Yeah, there'll be a vacancy. If it actually did carry on, Professor Sorensen is right. There would be a vacancy in the presidency as of noon on January 20th, at which point the Succession Act would kick in. So whoever was Speaker of the House at that moment would become, because the vice presidency would be vacated as well. So the Speaker of the House would become president. We don't need to go too far down that road, but the 20th Amendment, which comes after the Electoral Count Act that I talked about, would govern in that situation.
Great. Thank you all very much. Professor Rudalevige, Professor Sorensen, Professor Franz, thank you so much for your time this evening. On behalf of the McKean Center and the Government and Legal Studies Department, I hope you all have a great plan to vote and a great evening. Thank you very much.
Thanks.
Thank you.